Welcome, everyone, and thank you for joining us for another edition of Regulatory Hour. My name is Dave Vrelling, and I'm your Vice President for the Federation of State Boards of Physical Therapy Board of Directors. This year, FSBPT is taking what we learned in 2020 to increase our engagement with our membership through a variety of resources. We're expanding our educational lineup to include multiple monthly sessions. Each month in the webinar series, presenters address contemporary issues for regulators. The most recent topics include testing accommodations for licensure and how boards can address regulations in the post-COVID future. The additional session is Regulatory Hour with Dale Atkinson. Dale focuses on a regulatory topic and answers your most pressing questions about that issue. There are more programs that'll be arranged throughout the rest of this year, so please stay in touch with us. The FSBPT board recognizes the challenges of being in a virtual world, but we want to hear from you, understand the issues that you're dealing with, and be able to help from FSBPT. So if you want to reach out to me, if there's somebody that I can get you in touch with on the board of directors or a staff person, please feel to reach out and contact me, and I'm glad to be able to forward your issue to one of those individuals. Today, we're excited to have Dale Atkinson back for another session of Regulatory Hour. Dale received his law degree from Northwestern School of Law and does extensive presentations in the area of regulation. He's considered an expert and has worked with multiple different regulatory organizations over the years. Today's topic is I Want In, Applications and Renewals, with a review of information commonly utilized on licensure applications and renewals. Please stay around afterwards. We will continue in this Zoom web format for another session of Shop Talk. Shop Talk is just an optional, informal conversation that for you to connect with other members from the regulatory community and socialize and just maybe get some questions answered about some regulatory issues that you're currently facing. Questions for Dale's presentation today can be submitted in the chat function, or you can unmute and ask the question during Dale's presentation. This is a live Zoom meeting, so please, if you are not speaking, go ahead and mute yourself so that it doesn't interrupt the presentation. And with that, please join me in welcoming Dale Atkinson. Dale?
Dave, thank you so much for that nice introduction, and welcome to everyone. As emphasized by Dave, we do encourage you to participate, so please feel free to use the chat or unmute, and I will prompt you to use the chat or unmute and speak as well. So look forward to that. Dave called me an expert, and so I think the definition of an expert is if you carry a briefcase and you're more than 50 miles away from your house. Somehow I've heard that in the past, and so let's at least chuckle a little bit. I can hear you all laughing over the ether as I try to tell some of my bad jokes. So let me start out with all sincerity and seriousness to say thank you to not only FSBPT and its board of directors for dedicating time and its resources to these regulatory hours and other communications that it regularly is now having with you, the member boards of FSBPT. So a big thanks to the board of directors for allowing, if you will, this to happen and allowing me to be a part of it. Also a big thanks to the staff of FSBPT. I won't try to name them all because I'd leave someone out, but for all the work they do to put this together logistically and to assist all of us in being a part of an opportunity to exchange information. So thank you to the staff. And the biggest thanks goes to you all as regulators. You're not thanked enough. I say this at the start of all my presentations, so some of you have heard this before, but with all sincerity, the regulatory community plays such an important public protection role, and you are a big part of that, whether you are a staff person, administrator, executive director, whether you're a volunteer board member, an investigator, an assistant AG, or anyone else involved in this process. So a big thank you to each and every one of you for what it is you do for regulation and public protection, but also for being on the line today as well. So let's get ourselves moving along here. As mentioned, today's topic is about applications and renewals. I want in. There is significant litigation over the application and renewal process. And what I plan to focus on today is a bit of some of the bigger general pictures We don't have time to get into the nuances of language of applications and renewals too much, but if anybody has any thoughts, comments, questions, please put them in the chat room and or unmute and ask away, and we'll try to address those. We'll say for a future presentation where maybe there's more time to talk about some language issues in the applications and renewals themselves, but I'll try to get some of these concepts across. So welcome. And for those of you who are veterans of this, of these regulatory hours that I do, I usually have an animal chart like this, and everybody gets to pick a number, and usually it's dogs or cats making different faces. I got a chuckle out of this one because these cows all have the exact same face. So usually I would ask you to text in and identify with one of the particular faces up here. This is used today just to get a smile out of you all. So anyway, for what it's worth, if you haven't attended these past regulatory hours, you probably don't find this quite as entertaining, but anyway, let's just carry on. As well, as is tradition, I always put up a picture of a famous, if you will, lawyer as part of my own introduction. And so here's who I've chosen for this month. And there's several of them in every regulatory hour in past months. But as mentioned, I'm Dale Atkins, and I'm an attorney, a consultant to the FSPPT, and I represent a whole bunch of of associations of regulatory boards, just like FSPPT, including FSPPT. So the only reason I tell you that is, one, to let you know that you are not alone as a regulator, administrator, executive director, staff, or assistant AG, and use these opportunities to forge relationships with your peers, with each other. So I encourage you to do that. As far as Dave referring to me as an expert, most all of my clients have programs and services they provide to their member boards, which are regulatory boards from the states. And those programs and services are intended to lessen burdens on state government. Most all of my clients develop, administer, score, and maintain uniform licensure exam programs. So I'm involved in the psychometrics of the validation of those programs, as well as the administration side and the ADA questions and everything else that comes up. So suffice it to say, at least, that I am up to my eyeballs in regulatory issues, and hopefully some of my experiences, which now are in excess of 33 years representing associations like yours, hopefully my comments are helpful to you. So I tell you that at least to provide you with an opportunity to get to know each other, as well as myself and the staff of the FSPPT and your elected leadership. So if y'all want to start, just to make sure that I love the cows, excellent. I try to keep an eye on the chats, and staff has my permission to interrupt me if there's a chat that I happen to miss. So feel free, staff, to do that. But if you want to go ahead and chat in now, so we get a feel for who is on the call today. Are you a board member, an administrator, executive director? Are you other board staff at the state level? Do you work in a department? Maybe you're a department staff person. You might be an investigator, an attorney. If you want to just let us know who you are, it allows us to tailor our remarks a little bit, as well as some of the perspectives that might differ. And I imagine that most of you are executive directors. I see a lot of them coming up here, or program directors, or whatever the phrases might be, in part because of, one, the time commitment it takes to be on these regulatory hours, and two is the ability to take this information and then put it to good use, which executive directors may be in the best position to do that. So thank you for chiming in on that, giving us a little bit of an idea of who's listening in today, and we would customarily want to do that and get to know you guys. So a very quick recap. These are every month we're doing a different topic. We're on the I Want In now, and the next 3 months coming up, we'll have standard operating procedures, what it means to be efficient, communication protocols in November, and then we'll wrap it up with an in review in December of 2021 has led to change. You all are very familiar with the changes and some of the executive orders that have modified how you operate from a regulatory standpoint in your board. So you can see the previous topics, and I believe the board of directors of FSPPT is elected to continue to do this. So if you have ideas about topics or others, feel free to send them into staff, and they'll make sure that the right expert gets on the line and helps you all out in learning as we go. So let's start out now and just have somebody unmute. Go ahead, unmute, and just tell me, what is the purpose of applications and renewals for licensure? Well, in your guys' words, what is it? Anybody? Don't be shy.
To determine qualifications of our applicants to ensure they meet the regulations for license.
Excellent. And for anyone who unmutes, if you want to, you can identify yourself or at least your jurisdiction, and that will help us. You don't have to do that. And I can't see everybody on my screen. So, and obviously the purpose of applications is to collect information and ensure compliance with the law. Okay. And so some of the questions I'm going to get into in these upcoming slides is where the boundaries are between the law itself and what's required, and perhaps information that you deem to be necessary for purposes of what, determining identity or any other issues that might differentiate one applicant, now licensee, from another applicant, now licensee, or other issues that you can think of. And everyone ought to be thinking about, because I'm going to ask the question, I'll tell you now, is what is mandatory on your applications for licensure versus what is optional? And so be thinking about that, and perhaps we can get to a few recommendations when we do get there. So I'll have several slides about this type of discussion, and then I'm going to wrap it up with several cases that address some of these important legal issues and how they might surface. So I think we will not only fill our time, we'll have plenty of opportunity to perhaps use some of our cases to carry over into the future. So let's talk about perspectives very quickly. And I realize that we have an operational perspective. Likely most of the executive director, administrators, board staff on the line are thinking from an operational standpoint. And it's not to preclude you from thinking about the content standpoint, but perhaps the board members think about the content standpoint, or you all think about it from both. But I do want to let you realize I understand the differences and how it could be important. Because to operationalize some of the things that I suggest and some of the things that I say may not be as easy as me just saying them and you all just putting them into action if you think it's a good idea. And so I certainly understand that there are bureaucratic matters that have to be complied with in order to perhaps operationalize some of the ideas that you all are going to get out of this and formulate on your own behalf. And so on the left-hand side, the operational side, we have likely standalone boards, composite boards, and departmentalized setups, and those all may have a very different perspective. Standalone boards may be able to effectuate change very quickly and perhaps without a lot of bureaucratic involvement, if you will, other than within their own board itself. Same thing perhaps with composite boards. A composite board to me is one board regulating multiple professions. I'll go to mental health just because I work a lot in that, and it's easy for me to use that as an example. Professional counselors, marriage and family therapists, social workers might be regulated under one board, multiple professions, each with their own scope. And then we have departmentalized jurisdictions that usually are advisory boards that make recommendations up into the department, and the department has to take it from there. And perhaps those have a few more hoops to jump through in order to effectuate change. And so this operational side is important. The content side is where we'll spend most of our time today, and that is, what information do you need? What information do you have to have? And what about these subjective decisions? For instance, good moral character. What does it mean? And how do you differentiate between one who has it and one perhaps who does not have it? And what are the consequences, both legally and practically, about those decisions? So, and I can see, did I make some of these lines here? Oops, go back a slide. All right, so let's just talk about the information that is gathered. Demographics, okay, what does that mean and what do you gather? Who made these decisions on your applications and renewal, and what are you going to do about that? Education, the 3 E's, education, exam, experience, perhaps do come up. And we're gonna have a slide for some of these, so I'm gonna go through it quickly now to just set the stage. Employment, are you even interested in one's past employment situation? And then we get to this good moral character, criminal history, some might call it personal history. You all are going to phrase it in the appropriate way. And we ultimately have some kind of attestation in the end that the applicant says everything is true and correct. And what I've learned over the years, by the way, and so maybe the first take-home point that you can have out of this is, assure that your attestation clause says that I, the applicant, filled out the application. I work with some professions where English as a second language is an issue, and I have seen defenses by individuals who are accused of having misinformation on their applications, where they said, I didn't fill it out, I don't speak the language, or I don't speak the language well. and therefore I had someone fill it out for me. Please don't hold me accountable for the so-called misrepresentations or inaccuracies within that itself. And so the point of all this is that attestation can be extremely important to determine, one, that attestation to everything is true and correct, and two is that I filled out that application. And then lastly, I'll ask, and anybody can chime in the chat room or unmute, is do you collect a picture? And is a picture important or not? And are there reasons to not collect a picture versus you do that? As I have mentioned, most all of my clients are involved in the examination, development, and administration process. They do take pictures at the test center, and we have had individuals who have had imposters come in and take their exams for them, and we will use the pictures ultimately to determine whether the applicant at your jurisdiction is the same person who sat for the exam within the test center itself. So, again, there are a lot of reasons to ask questions about should we ask all these questions or not, and if so, what are we going to do with the information? So let's go to the demographics. And right now there's so much discussion over some of these issues. Some are extremely obvious: name or an alias, contact information. So an address, an email address, work versus home, previous addresses, and others. You're probably asking some questions along those lines. And eventually someone might say, well, why do you need all this information? Or perhaps just leave that blank. I don't want to give you my home address, for instance. I will only give you my work address, even though that's potentially subject to change, as is a home address, of course, as well. But it's your way of contacting these individuals. And it's the licensee applicant's responsibility to keep the board up to date on the location or contact information, so that you as a board can carry out your ultimate mission of, in part at least, of communication with your licensees. Sex and gender, obviously that's in the news now as to what it should say or not say, or do you even ask it at all? And there are some that are now saying, should we take this out of our applications? And again, there are pros and cons to every one of these on here, and you can ask yourself, well, gee, is that important to us? Perhaps for a workforce issue, it is important, maybe. Perhaps for investigative issues, if there's a complaint that comes in, your investigators might want to know if we're dealing with a man, a woman, or otherwise. And so you all are going to have to figure this out and decide what is best. But I will ask you again, as I asked earlier, is if you want to change your application for licensure or renewal, is that an easy thing to do? And effectuating that change. So be thinking about this as you're digesting what you think may be good or perhaps bad ideas that come out of this presentation. Race, ethnicity, or any other issues related to that. Again, obviously in the news right now. Physical characteristics: how tall are you, how much you weigh, what color are your eyes, what color is your hair? Do you need to know that? Do you want to know that? These used to be in applications for licensure and renewal, but perhaps they're not as common as they used to be. Marital status, do you want to know? And then lastly, financial disclosures. And is that covered in the personal history, which we'll get to in a minute here? But the financial disclosures of bankruptcy issues and others, is that even relevant to the issuance of a physical therapy license, as opposed to perhaps a CPA license or anything else? And so the profession that we're talking about may dictate the answers to some of these questions I bring up. But again, they're used for illustration purposes to make you all think. One, and two is you're going to ask yourself, well, what is the purpose of collecting this information? And is it required or not? So if I choose to leave any one of these categories blank, what happens? And how do you react as a board administratively? Does that result in a denial of licensure or a non-processing of the application? Do you keep the fees and others? So while I'm on the fee issue, by the way, and the filling out of an application, I'm assuming you all believe that fees are non-refundable. So let me give you an example of this. I file my application for licensure in your jurisdiction. I find out now I have to go be fingerprinted, and I'm going to go through a criminal background check. Perhaps I didn't think of that in advance. But now I'm a little bit wary about what might come out of those personal history evaluations and fingerprinting results. So I call the office and say, I want to withdraw my application. Please refund my money. And so how are you going to react to that? If it happens the next day, the next week, the next month, how are you going to react to that? I'm assuming that everyone on the line, and please feel free to unmute or put this in the chat comment. I'm assuming that fees are non-refundable and that there's not a circumstance where you would refund fees on a so-called withdrawn application. So that's question one is, and while I'm on this, question two is, do you even accept the withdrawal of an application? Is that even allowed, and why and under what circumstances might you accept it, and under what circumstances might you not accept it? So if anybody wants to unmute and comment about this, feel free to do that. But it's a very interesting question. Now, I, who probably am quite a stickler when it comes to the regulation of the professions, is I probably would not allow, let's assume I can do this, that I would not allow a withdrawal of an application. And if someone submits an application and it ultimately is not followed up upon, so for instance, I don't get my transcripts to your board and months go by, that should result in my mind, and this will sound harsh, I realize it, but in a denial. You chose not to follow through and get all the documents to the board that is necessary in order to make an informed licensure eligibility decision. And so therefore it results in a denial. Now, I have no problem. Let's say I'm that applicant and I moved to a different jurisdiction and I didn't follow through because my spouse got transferred and I moved. I have no problem saying to that next state, there's a denial of licensure in state A because I never finished following through because I moved to state B and now I'm seeking licensure here. And that to me makes quite a bit of sense. And that is a logical conclusion versus in state A, they're doing a criminal background check. So I fled that jurisdiction to state B to seek licensure, and then ultimately perhaps endorsing or reciprocating or compacting into another jurisdiction. So ask yourself these questions. Do you accept these withdrawals? What happened? Should you accept them? Should you not? That's one. And two is, what do you do with that application that sits and you don't have the completed file, of which I would strongly recommend, and whether this needs to be in statute, regs, or perhaps policy, that you say after X months, an application not completed is deemed to be, and finish that sentence for me, expired, denied, withdrawn, whatever it is you all think is best in your jurisdiction, but you put closure to that so your staff doesn't have to continue to track these pending applications. And if I then don't follow through, I'll reapply for licensure. That's okay. I start over again, but I pay another fee. The next big issue and I see a comment here is the application that sits incomplete, we keep for a year, okay, and then confidentially destroy per our records retention. Excellent. So I would have to start over again, I'm assuming in Virginia, to seek licensure of a now stale application, and I'd have to pay another fee and meet the current requirements at that time. So another big issue that does come up is this primary source documentation. And I spent a little bit of time on this topic because most of my clients have some kind of a system, a registry, if you will, where they store on behalf of practitioners information, test scores, primary source transcripts, continuing education completions, and others. And these registries then are used for mobility programs. And I know you all have a compact that has gained a lot of steam and everything. So there may be some relevance to this in jurisdictions and maybe not, but just keeping in mind the issue of primary source documentation. If it's held by FSBPT, to me, you should recognize it as primary source. And rather than have these candidates continue to go back to their educational programs and have new transcripts sent at an expense and a time delay and others. These barriers to immediate, if you will, licensure are what are attracting attention of both politicians and the media and lawyers as well, who want to challenge the process. So just think about it, from the standpoint of primary source. What does it mean? How's it interpreted? When is it required? We could be talking about educational transcripts. We could be talking about licensure status and good standing in other states, employment issues, references, anything related to an identification of the individual. So where is it that you all draw the lines? And by the way, you've all figured this out by now. Today's session, I probably ask a lot more questions than I try to answer, but the idea here is to identify issues and have you digest them and resolve them within your jurisdictions as to what's working or not. In the end, hopefully it makes you a little bit more efficient in your operations. And I emphasize the efficient, which is next month's topic, because of the perceived barriers to entry into a profession that is out there right now and that is being challenged. It takes too long. Perhaps things aren't necessary. So think about this primary source and think about how you perhaps can make these systems a bit more efficient. Before we get into the cases, we'll kind of round it out here with some personal history questions and at least an inquiry about that. So first off is it even relevant to the application process? And I'm going to make sure that everybody understands when I say application, I'm including the renewal process. So I'm seeking initial licensure, and is good moral character, for example, a prerequisite to licensure? And if it is, you're going to have to figure out, do I have that good moral character? And the burden is on me, the applicant. Everybody knows that. So when I'm seeking licensure, I have to show that I meet all the requirements. One of them may be good moral character. If it's not a requirement in statute, what do you do? And maybe you don't care. And so you're going to have to do an assessment of what your statute says first. So if it's a prerequisite to licensure, it's going to be in there, and you're going to ask a bunch of questions, and we've got some bullet points there. If it is not set forth in the statute, I would recommend your lawyers are going to read the grounds for discipline. And those grounds for discipline may say criminal conviction. It may say adverse action against a license from another board within your state. It may say an adverse action against your license from another state, interstate, and some other grounds there. And likely, if that is true in the grounds for discipline, you have a right to ask questions about the history of any licenses as a basis for determining eligibility for licensure, because it is very inefficient for you to grant a license and then turn right around and take that license away. That doesn't make a whole lot of sense, but again, we need to be careful about identifying this issue and how it is we're going to resolve this. So with that in mind, and with that little bit of foundation, let's just now make an assumption that good moral character is a prerequisite. It's in the statute where it needs to be. I don't believe that you can require good moral character in the regulations. I believe that's probably outside the bounds of the authority of the board, unless the statute asks you somehow to do that. But it's likely you'll find this language in the statute itself, authorizing your board to assess one's good moral character as a condition of licensure. And then secondly, as a renewal process, as we think about this, do not forget about good moral character. And I would recommend that your phrased question of personal history, which we're going to go through in a minute here, that you duplicate those in the renewals. And I would not get cute with language like, since your last renewal, have you done certain things or been subjected to certain things? Because eventually someone will be savvy enough to question the time frames and others, and there's a few cases where those have been successful. So you might say, in the last 5 years, have you been subjected to it? If you say that in the initial application, say it again in the renewal. And that way you're comparing apples to apples in the event of a concern over one's truthfulness on their application and or renewal. And don't forget about the ADA or any other disabilities laws at the state level that applies. So how you phrase these questions can be extremely important. That's a very complex, deep legal issue. Your lawyers will help you with that. But it's likely, if you ever see an application, the word like the phrase like, have you ever been, that is going to draw some attention versus closed time periods. Secondly, related to this issue, and it's not a disabilities issue, but this closed time period question are criminal convictions. There are a whole lot of second chance laws that are going on out there that will limit your board's ability to assess criminal convictions that may be old enough based upon the statute. They may have been determined to be too old. And there are some laws that right now that on the books that are saying felony convictions over 5 years perhaps cannot be considered as part of an assessment of one's licensure eligibility. So make sure you know about any of these laws related to second chance and others, and that you comply with them. Knowing those laws, you may have to modify the verbiage of your applications and renewals. So you can see on the list there, and there's some things that I want to emphasize that you don't forget. And that is licensure and other professions, both inter and intra-state. So you're going to want to ask individuals about not only their licensure status as physical therapists, both you should know within your state, but interstate. But you might want to ask them, or you should ask them, about licensure status of any other professional license. And it can be phrased in a manner that, have you been licensed in any other profession? What's the status of that license? So theoretically, one would disclose, I was licensed as a lawyer, and I no longer have that license. I allowed it to lapse because I became a physician. And it's good to know that, remembering that you ask for information so you make an informed decision on behalf of the public that you're protecting. And it's worthy of noting that. So access to the licensure exam, has that ever been denied? Another issue that's close to me because of the clients that I represent. And in some professions, individuals go to the FSBPT first to get access to the exam prior to seeking licensure. So if there's a problem on that exam access question, perhaps that's relevant to you as a board to know that. And that may not work, that example in physical therapy, but again, that's just another example, and it's to raise your level of awareness. An adverse action in an educational setting is again most likely protected under some FERPA and other laws that protect matters that occur within the educational program or institution itself. And so you asking that question might reveal something. And there was some very controversial issues recently in one of the Canadian provinces over dental students who engaged in some activity regarding the opposite sex, and they were disciplined within the school itself, and the school would not reveal information to the licensing boards. These were wannabe dentists. And so there's a gigantic dispute between the boards of all the provinces and this particular dental program. And so you can imagine how that would trigger some issues that might be very difficult to resolve under confidentiality, FERPA type issues versus self-disclosure. I don't want to go through all these and take up too much time, but if you surrendered a license, I would ask a question on that, because there are still boards that accept these voluntary surrenders. You should never, in my mind, accept a voluntary surrender. It's always a consent order. So, hey, you want to turn in your license, you're under investigation, here's a consent order, please sign it, and we'll move on. And that consent order will list everything it needs to list. But lapsed or expired licenses, what happens if I don't renew my license? Again, issues, complaints or investigations that are current or in the past. And then we move into the criminal side. And we haven't even gotten to the criminal side with all the bullet points we've put right there. And I guarantee you, with I do a whole lot of board training for my clients. And as soon as we get to good moral character, everybody goes to the criminal side. That's all they want to talk about, because they're not thinking about all these other aspects of other professional licenses, bankruptcies, financial, disclosures, or anything that you all have determined to be relevant. But we get into criminal, and in a criminal setting, you can get arrested, charged, and either convicted or exonerated. You can be pardoned and expunged. And so there's a lot of questions that can come out of that. And if I were developing an application for licensure and renewal from scratch, I would ask about arrests, charges, convictions, pardons, and expungements. I'm going to get some pushback, I think, from some lawyers about asking about expungements. But I believe criminal background checks disclose expungements. And I think your board has a right to know. How you use that expungement may be a different issue, but it could be a conglomeration of a lot of things that ultimately help you in deciding whether someone should or should not get that license. This is that subjective side, remember, because everything else is objective. I've graduated from an accredited program, passed the exam, et cetera. And then lastly, there's some mental health issues, treatment for addiction, treatment for any issues, obviously extremely confidential. You want to be wary of that. And then any civil issues, any military issues, civil cases, any military issues, and I've mentioned the financial issues a couple of times. While I'm on this slide, by the way, is to recommend to you another take-home point. If you're going to write down a few things, this would be one of them, is bifurcate your application. And that is, you're going to have part one that says everything on this application, part one is subject to disclosure under, and then cite the open records law. Part two is everything on part two of the application is not subject to disclosure, cite the law, and that might include social security numbers and other identifying information and or mental health or medical issues that you have asked for and are now storing. So keep in mind at least the potential for bifurcating the application. And the reason you do that is so when you get an open records request, it's easier to comply. And you're not going to have a mistake made when you're redacting confidential information from that complete application. Someone's going to make a mistake and there will be consequences that will come out of that mistake, unfortunately, included, for instance, like disclosing the social security number. So, all right, everybody with us? Somebody give me a thumbs up in the chat room there. Still going? You guys
Dale,
know that?
I do have a quick question for you, Dale.
Sure.
So just wondering about the information from educational settings. I've seen some jurisdictional boards utilize like a candidate waiver or a consent information in there. Does that allow the board then to receive more of that information from the educational setting, or allow the educational setting, I guess, to provide that information to the board?
So I think we're about out of time here, so I'll just wrap up. That's a great question. So the heart of the question is can you waive any of these rights that are granted under FERPA or otherwise? And I think the answer to that is likely yes. I think what would happen though is even if you had a waiver, the program is going to be quite reluctant to send it over, and you're going to still have this kind of dispute that might arise. But in general, I think, yeah, you can waive that, and that the school and the program should provide it. That case, Dalhousie was the name of the program, the school up in one of the provinces, Nova Scotia. I can't remember which one, so don't nobody write down Nova Scotia. But anyway, this issue did come up, not necessarily waivers, but the whole issue of sharing of information, which the school, I believe, to this date, never shared it. So you relied upon the applicant, the student, now applicant, to become a dentist to at least tell the story. And then you don't know if they're telling you the whole story and what ultimately had out of this. I was surprised that the school let these individuals graduate, but that's a good question again for everybody on the line today is graduation from the educational program. That's probably all that needs to be shown, because that's how your statutes are written, graduate from an accredited program. And what happened in that program, perhaps you don't care about, but maybe you do. But maybe the school has now made that decision. We're going to go ahead and matriculate these students through. That's a really good question, Dave. And I think the answer is yes, you can waive it. I'm not sure the schools would necessarily jump to comply even with a waiver that you flashed around. So more to be said perhaps about that. All right. So I've got a couple slides and I'll reference you to the FAR model application for licensure and renewal. I only have these couple of slides up here just for some language-driven purposes, and I've highlighted or underlined a few things. Failure to disclose all requested information may result in this form not being processed. So this kind of gets to my question of what is mandatory versus what is not. And I'm going to continue to ask you guys that question. Here also it says that you have a continuing obligation to update and supplement information. Is that true in your jurisdictions? I hope so. So that once I submit my application, if something new crops up or I forgot to disclose something, I have an obligation to tell your board so that you know that. And then that last line that's underlined, please note that the information provided on this application is subject to the public information laws of this jurisdiction. Does that mean everything is going to be disclosed? Probably not. Hence my bifurcated application, where you identify to those candidates what will and perhaps what will not be disclosed. So keep that in mind. That's a difficult question, and ask your lawyers that as well. This is just one more slide taken from the FAR model application. You can see type or print legibly, and I realize you all are probably now, this is a few years old, that you all are doing some kind of online electronic presence. But you can see under number 2 there, very clearly the application fee is not refundable. And then importantly, where you have something that is, where you have a field that is required and the failure to fill that field out will result in a denial, that's what number 3 is intended to address. Disclosure of your social security number is mandatory. You cite the law. There's a federal statute that requires licensing boards in the states to collect that for all sorts of purposes, including child support, alimony issues, tax issues, and otherwise. But that is a clear statement there. And it may also, you may also want to say mandatory on your application right on the field itself. Now, when I say that, I realize, does that mean that every other field is optional? So you guys ask yourself that question. Is it optional? And what happens if I do leave some other fields blank that are not necessarily key to assessing and proving, if you will, my eligibility? So a couple of cases now here, but if anybody has any questions, please feel free to unmute, ask, and or type them in the chat. So any questions so far about the application itself? Does somebody want to tell me what is mandatory versus what is not in your jurisdiction, and the consequences of a field that is left open? What do you do? I don't want to give you my email address. Anybody? I would suggest that if you're going to not process, which to me is akin to deny, no matter what you call it, it means I'm not getting my license anytime soon. If you are going to not process an application because I didn't fill out a field of my previous employment, or because I don't want to give you my home address, or you think of your example, I am going to ask, where in the statute is that a requirement for licensure eligibility determinations? And there's no good answer to this question. And I see somebody just typed in, everything is mandatory, and nothing is mandatory. Is that what that says? Yeah. So you sound like a lawyer, by the way. So Jason, you're probably a law school graduate. There's no good answer to this. And I agree with what all the administrators are now saying, is we don't want to put mandatory on some and optional on the others, although there's a few optional ones related to, I'm sure, ethnicity, race, and those types are probably deemed to be optional by your boards. Figure this out. There is no good answer to this question. And I assume if I leave some items blank, you're going to send it back and forth and try to get me to answer them. And I also assume that most all of you get all the information eventually. But what if someone starts to refuse, and be ready for that? And what might you do? So this first case here that we're going to deal with is a 2021 case out of Florida. A person who was already licensed as a physician who had in Florida, and they had their Alabama license revoked. And don't even get me started on the revocation versus suspension, what that means. That's a topic for another day, but everybody ought to know what revocation means and whether you like it or not. But the Alabama Commission revoked the license because of fraud on the application in Alabama. And this is all related to graduating from an accredited program. This was a foreign graduate. And so there was a lot of issues at stake here that got a little complicated. But what happened was Florida revoked the license of the physician based upon the Alabama revocation. So this is that reciprocal discipline, if you will. And this case was driven by, and the Alabama decision was driven by competence, because they said this physician didn't establish competence insofar as the application to be a physician. The physician in this case here, in the 2021 case cited, was seeking a stay of the revocation, meaning that the board cannot enforce that revocation until such time as it's appealed and others, and was successful on the stay. So different topic, what do stays mean, and when do you enforce your final adverse action? And the short answer to that is you will enforce it until a court tells you you can't enforce it. And by the way, that includes publication on your websites and otherwise. But So this 2021 case dealt with a fraud on the application or in Alabama, resulting in the Florida revocation of licensure. So you guys now figured that out in the application side. The important thing is how does Florida know about Alabama's decision? Super important that you guys participate in the FSBBT programs, including their exam, licensure, disciplinary data bank. Is that ELDD? Did I get that right? Okay, so the ELDD, if you don't know what that is, ask questions in the follow-up half an hour that we're approaching here in 15 minutes. So this next case is one of my favorite cases. It's an older case, and it deals with a municipal granted license for a crane operator. And this is out of New York, and it comes out of I believe the county where New York City is located. So the bottom line of this case is an individual who was this crane operator had a license. He was convicted of a crime. He was actually incarcerated, and these crimes had to do with conspiracy and fraud and receiving of monies and a sham, if you will, contracting business. So it was related, if you will, to his crane operating license. Again, municipal driven. He disclosed his criminal convictions on his application and his renewals. And if I recall correctly, the facts of this case, he actually was educated in part while he was incarcerated. So this whole question of individuals who are educated in prison get out, and then that prison time is a bar to licensure in the profession which they were taught. And this happens, say, in cosmetology, barbers and others that come up. But the point is that in this particular case, he disclosed his convictions. Okay. Secondly, he disclosed his convictions, I believe, on 3 licensure renewal applications. And on the third one, the board said, it's actually a commission, but the commission said, well, gee, based upon that criminal conviction, we're not going to renew your license. So here's something that's been disclosed multiple times to the licensing entity, now being used on the third renewal cycle as a bar to renewal. And we are going to react to this case in one way or another. You might think that's unfair, or you might think that's a great decision, or the right decision. Maybe not great, the right decision and otherwise. And so, I would make an argument here of estoppel, that the board is stopped from not renewing my license. Those arguments were unsuccessful, and his criminal conviction did act as a bar to renewal of licensure, in spite of the fact it was disclosed both originally and on 2, ultimately 3 subsequent renewal cycles. So that's a perhaps logical conclusion, as unfair as it sounds, because the board may not have been able to check or had the wherewithal to check every single application like this. So I know you all are reacting to that in your minds right now. So if anybody has any comments about that, feel free to chime in and ask that. This next case is also a 2021 case. We have to have a lawyer case, someone seeking licensure as a lawyer. And in this particular case, the individual graduated from law school in Louisiana in 2002. There's a whole lot in this case. I don't want to run out of time, so I'm not going to tell you too much, but he graduated in 2002. And he sought his license in Louisiana, and he had a criminal conviction, and based upon what some would call statutory rape or carnal knowledge of a female, he was placed on probation, and he was denied his license in Louisiana. He went to Texas, and he was eventually given a license in Texas, I believe in 2006. He was also licensed in the District of Columbia in 2009. He did fully disclose his criminal background in both Texas and District of Columbia. And he eventually lost his license in Texas because he did not register as a sex offender as he was required. Now, what had happened in the interim is he got a first offender pardon, and he had the conviction expunged. So now we're back to this question of, is that even relevant now? And can a board ask it one, and can it, if it does ask it and get information, can it use that information against it? These second chance legislation probably would address an issue like this. In most of the professions, this is a law case, and those don't exist that I know of, at least in Arkansas here. So he was seeking now licensure in Arkansas. I think I probably didn't tell you that. So all sorts of things happened. He was denied his license in Arkansas, and the Supreme Court of Arkansas upheld that denial based upon all this fact pattern. But we can see now some jurisdictions, Texas and DC, allowed him to be licensed. Louisiana said no, and Arkansas said no. So we will end up with some of these inconsistencies from jurisdiction to jurisdiction, which are going to be premised upon the same facts. And theoretically, if you disclose everything, should we all reach the same decision, jurisdiction to jurisdiction? I don't know. You guys can try to answer that question as well. So this is actually a physical therapy case, and I put this in here because you all want to have a physical therapy case, even though it's from 1999. And here we had an issue of an individual who is seeking to reciprocate, and the compact is going to solve some of these problems, but let's just zip through this case quickly so you hear an example. Reciprocating from Vermont to Delaware. Now, what had happened is, in Delaware said you need a certificate of good standing from a state in order to reciprocate into Delaware, and his Vermont license had been withdrawn. So question number one is, what is a withdrawal of licensure? So I would suggest that everybody on the line today, that you all understand that when you try to be sensitive to issues related to licensees, and you maybe come up with a new term or a new way to say, well, since you're leaving our state, and obviously you're not going to say all this out loud, but since you're leaving our state, well, let's just treat something a different way. And we'll treat it as a withdrawn license. I don't know what a withdrawn license is. So the question is a withdrawn license in good standing or not? The answer is no, it's not in good standing. But I would suggest to you, what is in good standing? And you guys can answer that question for me. If I'm on probation, is that in good standing? If I've been subject to past discipline, but now I've been reinstated, if you will, is that good standing? If I, been subject to a reprimand, a censure, anything else, at what point in time do I go from good standing to not good standing? And at what point in time will you provide a good standing certificate to another jurisdiction if I'm seeking to move? Your compact obviously resolves this because of the privilege that I'm granted. If I'm licensed in my home state, I can practice in compact states. So that's a good thing. That's an efficiency thing. It should work out great. But I have this case in here just because of that withdrawal issue. By the way, this individual not only was denied in Delaware on the reciprocal, the individual then turned and said, well, let me take the exam and become licensed through the examination. And they said no. And so that's a really good question, is what is a reciprocation versus what is an original licensure if I'm licensed in another jurisdiction. So, all right, last couple of cases here in our last few minutes. Here is this Istanbuli case out of Ohio. It's a medical case. And here the individual was asked the question of, at any time since signing your last application for renewal of your certificate, have you, and then there's a bunch of subcategories. One of them have been notified by any board, bureau, department, agency, or other body, including those in Ohio, other than this board, the medical board, of any investigation concerning you or any charges, allegations, or complaints filed against you. So that's really wordy, first off. But figure it out what's best for you. What I don't like about this renewal application is at any time since signing your last application. I would phrase this in a manner of time frames in the last 2 years, 3 years, 5 years, 1 year, whatever you guys think is appropriate, and ask that consistently throughout so you have enough overlap. Since your last application really would be subject to some serious, I think, interpretation if I try to do certain things just outside of that renewal and otherwise. And there's a couple of examples for that, but I wanted to bring this case to your attention because of that question. And then secondly, this dude argued that I'm not under investigation. Yes, I was subject to discipline, but you didn't ask me that. You asked if I was under investigation. And so he was unsuccessful on this as well. But how you phrase your questions can be very important. It might paint you into a corner. The last couple of cases here, this is another law case here, or excuse me, a realtor for a license. And this person used to be a lawyer, had his license revoked as a lawyer. He went over to become a real estate agent. And the questions came up is, did he tell the truth on his application to become a real estate agent when he was subject to his loss of license for a 2-year period of his law license? And so was he forthright with the board itself? In this case, they asked him this on his application for licensure: are you licensed in another licensing jurisdiction in this profession? So that would be real estate, and he's not. And then, since your last renewal, has a licensing jurisdiction taken any disciplinary action against you? He interpreted that to be any other real estate board, and so he said no. And that's just confusing language. Be super clear. Make sure you read your language over and over again. He was unsuccessful in his argument there, but that is that is something we can learn from related to that. And then in this Barn Grover case, a medical licensure case, this is also from 2002, so it's a little bit old there, but he was licensed in both Alabama and Georgia. And the question asked him on his renewal application is, to your knowledge, are you the subject of an investigation by any licensing board agency as of the date of this application within the last year? And that seems to be really awkwardly worded, as of the date of this application within the last year. And so he answered the question no, when he should have answered it yes, but the question was very poorly worded. But it was upheld, his sanction, based upon not being truthful in that application. The point of this bottom line is that phrase your questions carefully, so you don't run into ambiguity, because even though you're successful as a board, which most likely you will be, you still had to fight the fight. It cost you time, money, effort. You might have been in the news and otherwise. So be wary of that. So I am right at my time. I know you all are going to stay on, but and I will stay on as well. But anybody have any questions or comments? Hopefully this was helpful. There's a few take-home points maybe you got out of this. But how your applications and renewal are phrased is so important. So read and reread them and get your lawyers to weigh in on these issues. So
Dale, there is a question in the chat here. It says, what do you suggest for applicants that have disciplinary action in another jurisdiction, but say they didn't read the question correctly or didn't understand it? This jurisdiction seems to have that issue occasionally.
I think be prepared. That will be the defense on every single one. It'll be one of the defenses is I didn't read it carefully. Unfortunately, the short answer to that is too bad. Read them carefully. If you're not sure, get some legal advice, and if and follow that advice. Part of the problem with this is how the questions are phrased, but I'm not as sympathetic as perhaps you would like me to be if somebody just merely says, I didn't read it correctly. They're saying they didn't read it carefully. They're also probably saying, I wanted to answer this a different way. What was the correct answer? The question is this a mitigating or an aggravating circumstance? And you'll probably take each one of those case by case. So great question, hard to answer, but be ready. You're going to hear that all the time. All the time.
Thank you, Dale, for another great presentation and giving us all as regulators some key issues to think about with our applications and for our renewals. For everybody here, thank you for joining us. We hope that you will be able to use today's topic to inform your work as regulators.